Hello everybody, welcome to our group video presentation for business and corporation law. Today we are going to talk about two cases for business law and we are group of 5. We have chosen two questions for our video presentation. So let's start with our first case. First case is SO Burgers, that is a chain of hamburger restaurants operating in Australia and New Zealand. To promote the sale of its business, it announced a fair income deal which says collect 50 tokens each available on every double-decker Emu Burgers to get golden scratch ticket to reveal and win Mazda CX-9 car. So, two people, Michael and Brett, they try to collect tokens and to win the grand prize. But Michael, however, purchases 50 burgers at once and try to eat it and gets hospitalized by eating too much. Whereas Brett went through the bins and collects the discarded tokens. Both of them are successful on getting golden scratch tickets. However, company claimed that it was because of printing error. So the issue here is there a binding contract between them? 2. Is SO Burgers liable to pay both Michael and Brett?
In these cases, the rules that apply are 3 elements of legal binding contract. First one, legal intention. Second one, agreement, offer and acceptance. Third one, consideration. First things, to make a valid contract, a lawful relationship is always necessary. Next important element to a contract are the offer and acceptance. Binding the Australian contract law, the offer and acceptance is essential. The offer would be termed as a valid one when a proposal is made by one person to all the others at large. The law contract that offer can be made one to one or one to many in the written statement or words. Acceptance is another part of that goes hand to hand with the offer. Acceptance is for contract law states that all the proposal in offer need to be accepted and need to be communicated before the termination of the offer. Third element of binding contract is consideration. The term consideration is anything that is exchanged between the parties. According to the law, all the contract must have consideration but is not need to be adequate.
Applying these rules to the case of SO Burger, first element legal information is satisfied. So SO Burger made public announcement. Court assumed that there is legal intention of the restaurant to sue or to be sued. Now, second element comes as offer and acceptance. As it is an offer made to the large public, anyone purchasing burger and collecting tokens are assumed to be accepting the offer. Hence, when both Michael and Brett collected the tokens, they have accepted the offer to make it valid legal contract. However, one important aspect of the legal agreement, it must be communicated to the offerer before the termination of the offer. Now the third aspect, Brett, who went to the head office to show a golden ticket, has communicated before head office announced the termination of the contract. However, in case of Michael, who reached company after the termination of offer has been announced, did not satisfy the communication requirement of the valid contract.
Hence, as discussed by my friends, in the case of Brett versus SO Burgers, all 3 elements of a contract to make it legally binding has been completely satisfied, and court will hold SO Burgers liable for the price claimed by Brett. The only defense for SO Burgers in this case, however, is if they have the term in the offer to be needing all the records of the purchase receipt on Brett's name to the claim. Even the excuse for printing error will not be accepted to reduce the liability, as in the case of ANZ Banking Group versus Westpac for the case of final payment versus mistaken payment. However, in the case of Michael, as one of the element of the acceptance is missing, that is communication of acceptance before termination of the offer. Hence, Michael will not be compensated by the court. So, let's start our second law question, that is corporation law questions. And in this case, Felix, Greg and Mercedes are 3 directors of Zoetronics Private Limited. To retain the profit and expand the market lost because of the competition, Greg and Mercedes agreed to Felix's decision to open up a new store in Parramatta without doing any background check, market research, and budget estimation and financial status of the company. However, the things didn't go well. The store doesn't do very well, and now the issues in this case here are: have Mercedes and Greg breached any of the director's duty? Do they have any defense? What are the possible liabilities if Joytronics becomes insolvent?
I'm now going to describe about the rules for the Joytronics company. The rules include the common law states that the director should act in a good faith to use the care, diligence and skill, and the duties are owed to the company. Similarly, the statutory duties on by the directors are explained in 180, subsection 1, section 181, section 182, section 183 and section 588G. According to the Companies Act 2013, Section 166, managing directors must exercise due and reasonable care, skill and diligence and act in good faith. Section 180 describes 3 directors have the responsibility and should have knowledge regarding the performance of business and financial position. According to the Corporation Act 2001, Section 181, explains the duty of good faith means directors should act in a good faith plus act in the best interest of the company. Similarly, Corporation Act 2001, Section 180 describes care and diligence and civil obligation. Sections 180, subsections 2 says business judgment rules applies in respect of the statutory duty of the care and diligence. The last one is according to the Corporation Act 2001, Section 588G, which describes a table of the debate that has incurred. Section 588G, subsection 3 explains that person commit an offensive provision if the business is insolvent at that time or the turns out to be insolvent if the debt has been incurred. However, 588H gives directors a defense. This section protects director when they reasonably ground illness or take responsible steps before the company becomes solvent.
Is director participate in the board meeting, helping to make decision and ensure that the company obligations are fulfilled. According to the S180 general law, director must act on good faith and should avoid conflict of interest. So director must be skilled, experienced and adopt duty of care and diligence and try to find sufficient information before making any decision. Mercedes is liable for any breaches because it is a duty of care and diligence of the director in regard to the company financial affair. Hence, all director must be well informed with company activities. Hence, in the case, court can find that the director has breached their duty of care because they had failed to take reasonable step and safeguard their position. Moreover, she fails to exercise duty of care and diligence required to review the Felix plan for relocation of store. Yes, 182 or statutory business judgment rules provide director to make business judgment in accordance to S 181 to make judgment in good faith for proper purpose and doesn't have any material and personal interest. Also, they should have be informed properly for subject matter and believe it is appropriate and true, along with belief it is the best for the company interest. Hence, her decision to agree to purchase of new premises is not protected by S182 because she breaches one condition of fully having knowledge of subject material and she didn't use her diligence and due care. Felix breaches S588G being dishonest about the circumstances. Although Mercedes knows the sales are lowering in the period of time due to competition, S588G implies in the Mercedes case she is also a non-executive director because she was reliant with Felix's advice of relocating to Parramatta site for growth of the company. Hence, turning a blind eye and trusting others is not the defense for the non-executive director, so they are liable for any fines or penalty that imply. So it is the breaches of S588G to she was aware that time they are good for the suspect that company might become insolvent in the future.
Hence, in conclusion, in the case of Greg, as being director of the company, he doesn't apply any due care and diligence in making decision under Section 180. And he doesn't even use his statutory business judgment without fully understanding the subject matter. He just gives his consent in shifting the store from Sydney to Parramatta. Regardless of their experience, directors should be familiar with the operation of the business. Moreover, if they don't have the experience in the different aspect of the business, they should make inquiries about the unknown tax, what is missing. Hence, directors can take commercial risks, but it should not be due to the ignorance. And if they fail to make inquiry, is a liability for the tort, as in the case of Daniel and Ors versus Anderson and Ors. So, in the given case of Zoetronics, both Mercedes and Greg breached the duty by failing to consider sufficient information for rational decisions.